Good afternoon, everyone, and welcome to the Assets and Infrastructure Committee meeting. I'd like to welcome everyone on board and anyone who may be joining us online. We do have one apology from Councillor Linwood, who is unwell. I think everyone else we have here today. Do we have any declarations of interest? Nope. Righto. On to item number 4, the confirmation of non-confidential minutes. Is anyone happy to move?
Yeah, Mr. Chair, I'm happy to move, but with one very minor correction. Apologies for this, but on page 6 of the agenda, under the general heading discussion, 4th paragraph, there should be a full stop after the word moment.
Thank you. With that, is anyone happy to second that? I'll second that. Thank you, Councillor Holding. Move, Councillor. All those in favour? Against? Moved. Righto, on to our reports, and the first one is on wastewater laterals policy, and I'll hand over to you, Mr. Cook, to introduce this paper.
I'm happy to go straight to the officer.
Straight to Mr. Rendell. Thank you very much.
Thank you very much. The purpose of this report is to seek a recommendation from the Assets and Infrastructure Committee that Council adopt a policy around wastewater laterals. Wastewater laterals are essentially the connecting pipe between a private household or business to council-owned sewer mains. At the moment, they are privately owned, so council accepts no obligation for maintenance, inspection, repair, etc. However, they do run within council's asset. They predominantly run within road reserve and they connect to council's wastewater mains. What the policy seeks is that where council is otherwise investing in its own infrastructure, be it wastewater main renewals or road rehabilitations, etc., or where a partner such as NZTA is also undertaking significant works, that council may intervene on behalf of the private property owner and inspect the lateral to determine whether it's in a fair condition or not, and if necessary, take steps to remediate its condition prior to further investment being made within the road reserve or council's wastewater main to ensure that we're getting the best overall outcome with the dollars that we're spending on public infrastructure. So to an extent, it allows council or officers to take steps to work on private property, which without this policy in place, we're not able to do so, to protect council's own investment or NZTA's investment in infrastructure.
Thank you. And I guess one of the questions that I had right at the start, just to be clear around this, I mean, whilst this would normally sit with the landowner or the property owner, this is us sort of being proactive if we're already investing in that infrastructure, obviously for what I would deemed to be usually quite a minor amount overall. We're just trying to get things all up to date and save us from coming back and digging a road up or another pipe further down the track. Would that be correct?
Yes, that's correct. Yep. And we do so only with the agreement of the property owner, on the understanding that council doesn't accept future responsibility for the lateral, that it's only doing whatever repairs are necessary to ensure that its own investment in infrastructure is protected.
Thank you. Do any other councillors? Councillor Schlack.
Thank you, Mr. Chair. Mr. Rendell, I just refer by example to where are we? We are page 14 and a couple of paragraphs down. It starts, the key feature of the policy is the separation between ownership and intervention. And as you have just mentioned, any repairs to lateral sewer offtakes are going to be with permission of the landowner. However, what is actually going to happen? What is our legal position if the landowner, for whatever reason, basically refuses to, for council to repair a connection to our own main sewer line? In situations like that, because I'm sure that we don't like to have a main sewer line under repair and then not touch a lateral sewer line coming into it that is leaking or creates another issue. What do we do then? Have we got a legal position on that?
Yes. Yep. So in the instance where the property owner or the landowner doesn't want us to undertake work on their private sewer lateral, where we can see that there is a concern that it's not in a good condition, and we are needing to renew an asset over the top of it, we would obviously inform that landowner that their main connection is not in good condition, and inform them of their obligations with respect to any fault that we would find in the road pavement or within our infrastructure that may be because of a failure for them to undertake works, or in this case, a failure for us to undertake works on their behalf. This becomes a significant issue when we're working within state highways in particular, and NZTA has undertaken a significant road rehabilitation program. They tend to spend millions and millions of dollars on road pavement rehabs in the highway. And historically, there have been instances where private laterals have shown to contribute to defects. And NZTA has then come to council as the owner of the wastewater network for its liability, which we then have to pass on to private property owners. So I suppose it is in everyone's best interest that council be able to undertake the works, because it's going to save us a lot of money up front. But if the property owner doesn't want to, then we'll just need to inform them of their obligations in terms of managing their own infrastructure, and let them deal with whatever liability comes from that.
Councillor McCone, Councillor Holding, and then Councillor Hopkins, please.
I'm thinking the other way, Josh. So when you have that connection that's in the middle of council property, i.e. a road or a pathway or anything else, you can't physically touch without going through a whole lot of systems to get it done. So would it be possible, the same as water? So where your water connection is, which is on your boundary, can that be the same with the wastewater? And that way, rather than have to go through a whole lot of rigmaroles to join into an existing main in the middle of council property, you are responsible from that boundary line back to your property.
Through the chair, yes, council could make a determination that it wishes to change where the transfer of responsibility or ownership is. Wastewater laterals, the ownership of them is different amongst different council areas. What I suppose, not wanting to do is to get into a significant conversation around the ownership of wastewater laterals, because it forms a significant liability for all of council's ratepayers in us accepting ownership of them, because a lot of them are in very, very poor condition or haven't been renewed. I see what I was trying to put forward here as a limited liability scenario rather than a full liability scenario. And then given the infrastructure itself is going to pass over to Southern Waters, I was going to let them come up with a solution as to where they want the point of exchange between ownership to be made, because they do have 4 different councils and not all of us have a consistent viewpoint at the moment.
I sort of half by guess that's what you're up to, but so in that, how is there a lifespan on this document? Is there a caveat where it's got to be reviewed?
Yeah, that's true.
Yes, within the policy itself, there is a lifespan on it. So it only pertains to Waitaki District Council itself, and on any exchange of ownership of the wastewater assets, the policy would lapse. So this really just deals with what we're looking at for the next 12-month period.
Councillor Holden.
I think this has been covered off. I was just going to ask if it was just a probably annual life shelf of this policy until it transfers, as Josh said. I think CODC is a private ownership versus our one. So yeah, that's been answered.
Councillor Hopkins.
Thank you, Mr. Chair. Yeah, I note on page 14 the clear prerequisite that this can only happen once the consent of the private sewer lateral owner has been secured. I have a question on page 23. There is a slight grammatical thing on the last sentence: for the avoidance of doubt, this policy and any obligations cited within do not transfer, because they're plural. But the question I have is, when we signed the document relating to the CCO, I was under the impression that essentially that consigned everything we had to them. And they were in the position of being able to say yay or nay. And they could certainly rescind or review contracts and so on. But I would have thought that to the extent that we've made this part of our network, the notion that we can't transfer it to the CCO contravenes the agreement we've signed regarding joining the CCO. Am I correct in that?
So I do believe that transfer of assets will occur on the 30th of June 2027, or rather the 1st of July 2027. So this policy would only be in place until such time as the assets do transfer. In the intervening period between now and transfer of assets, I do believe Southern Waters are going to take a viewpoint on whether wastewater laterals will be considered private assets or public assets. As I've said before, 2 of the councils currently treat them as public assets. The other one, plus ourselves, treat them as private assets. So I think this issue will have to be resolved. Looking to just have something in place for the next 12-month period while we invest quite a lot of money in wastewater main renewals and road rehabilitations.
So to be clear, we need to establish clear understanding as to the ownership of the lateral before we determine whether it should or should not go to the CCO as part of our portfolio. Yeah, okay. My other question, if I may, Mr. Chair, on page 30, you've got the 1, 2, 3, 4, 5, 6 boxes that people tick. Looking at number 5, I just wonder, for purposes of clarity and to be absolutely explicitly clear, whether we shouldn't add a couple of words. I understand that future maintenance, repair and replacement responsibilities of the privately owned lateral remain with the property owner, because at the moment it's a very general proposition and may possibly be misconstrued. Would that addition make sense?
Yes, I believe so. If I may, I'd really appreciate receiving any grammatical or spelling issues, and I can fix those up within the policy itself before it goes to council. I haven't had these go through a thorough review process for grammatical issues.
Yeah, I think we had a quick discussion prior, and there's a couple of little bits and pieces that Councillor Schleck would like to tidy up as well. And if you'd like to email Josh your concerns around that, we can certainly get that done before this document comes back to council. Now, Councillor Thowling, whilst not on the committee, councillors are welcome to be here and have a discussion. Won't be voting, but by all means.
Just reading through it, maybe it's in the sewer laterals ownership policy, which I haven't read, but if you've got a property where the sewer runs through another property and then is connected to the mains, are both those properties covered by this policy? Would they be splitting any cost that was to arise?
Yes, yeah, but where a sewer lateral is running through another property, it's unlikely that we would look to remediate it because any damage would be dealt to another property as opposed to within council's road reserve. So it would depend on what the impact of not repairing or remediating the asset would be on council's infrastructure, and we'd make an assessment based on us ensuring we get adequate investment from our spend in infrastructure.
Okay, well, I think we've had enough discussion on that topic. If anyone who has, you happy to move? Do I have a seconder for that? Councillor Schlack, moved. Councillor Hopkins, all in favour?
Aye.
Against? That's carried. Thank you. Sorry, I'll get on to the next one. 5.2, update on infrastructure, health and hygiene compliance. I guess again, happy for straight to Mr. Rendell to introduce this one. Thank you.
Thank you very much. The report that I brought to you last time round was a bit more of a comprehensive performance report where we were looking at finances, contracts, as well as compliance. This time round, we are just looking at compliance, and that is purely with where we're at in terms of financial year. It didn't really make sense to leave 1 month left of a financial year before I reported on performance. But the report itself outlines where we're sitting in terms of compliance for water, wastewater, stormwater, and trade waste issues. You'll note on page 36, there is a sort of a red, amber, green traffic light system that's showing where we're meeting in terms of compliance. We have tweaked with some of the colours in there for clarity. You'll see that in the drinking water space in particular, there's quite a lot of reds there. We have quite a few of our suppliers that are not meeting the drinking water quality assurance rules. Within water safety plans, we're still doing some further work on improving some of those, which is why we've got other suppliers denoted as amber. Within our water take consents, we still have a few outstanding issues. Some of those are technical issues with regard to resource consents, but other those are of concern. And in the wastewater space, we do still have some active abatement notices. Happy to take any questions from the floor.
Yeah, look, thanks, Josh. And look, the report in here with the green, amber, and red really easy and to read. And thank you very much for giving us an update here. The no surprises is a really good place to start from, so that we understand what's coming in front of us. I guess first of all, a question for myself is where we've got the red and the not. I understand, but a lot of this work needs to be done before we hand over to the CCO. Is that correct?
Absolutely. Yes. Yep. That is the plan. We have quite a significant capital works program planned for the next 12-month period before we hand over responsibility of these assets to the Southern Waters CCO. The goal is to try to get these all compliant. I'm hopeful that we'll meet that timeframe. But given that directors of a company have personal liability as opposed to the general liability the council has, it'll be then up to them whether they assume responsibility of any suppliers that are non-compliant.
Mr. Cook.
Yeah, I think it's important to note, though, that there has been progress made. Duntroon has gone to green with the installation of the UV upgrade. And you'll also remember that not many meetings ago, council approved the procurement for all the Corridor schemes, and that is now progressing and is on track to be compliant by the deadline.
Thank you. Councillor McCone.
You're waiting for that, weren't you? So a lot of these compliance things will be more technical than actually risk, or I'm assuming, I'm not going any further than that, but the second part of that is years ago it was talked about that the nitrate levels out in the Owataki were going up and down quite a bit, and it was talked about hooking on to the end of the treatment station here and actually going out there. Is that still on the cards? Because I don't think the nitrate levels are going to disappear.
With respect to the first question, I can't get into whether they're risk or technical issues, that they are issues. The drinking water quality assurance rules are there to ensure that we manage risk appropriately on the suppliers. So if we're not meeting the rules, that is of concern. And then with respect to the Lower Waitaki, yes, correct. Nitrates are sitting at around 50% of the maximum acceptable value at the moment. Longer term, the plan is to connect it to the Waimaru scheme. We'll be looking to do that at the same time as Lower Waitaki Irrigation Company upgrade its system, assuming they do so, to try to save some costs in terms of capital.
Thank you, Josh, and appreciate the political answers to the first part.
Councillors Holding, Hopkins, and then Schleck, please.
Do any of the abatement notices come with financial penalty, or more of a?
Yes, they do. Yep. At the moment, we have sought extensions to the abatement notices, so we're not actively receiving fines. However, those do lapse at the end of this financial year. We're currently preparing a report to ORC that gives them an update on the steps that we've undertaken to try to get within compliance. Because some of the values that are assessed are rolling 12-month averages, even though we've made some improvements, we're still not compliant yet. So we'll, write a letter to them and see what they think of our progress so far and determine whether another extension is possible. If no further extension is possible, there will be further fines.
Josh, just on that, have you sort of, obviously you've been having ongoing conversations throughout this. Do you have a feel for where that might end up? Do you think, are they receptive to, as long as we're making some progress to extending, do you think? Councillor Cook. Sorry, Mr. Cook. Councillor Bushville.
I think I've referred to it before. There's quite extensive relationship management with ORC, and at the moment they see that we are got best efforts to correct some of these matters. However, I guess like anybody, they only have a certain amount of patience. So we keep working on that relationship, and we continue to push to get compliant.
Thank you. Councillor Hopkins.
Thank you, Mr. Chair. I've got 3 questions. 2 of them on page 33 and 1 on 34. On page 33, second paragraph, I simply don't understand the last sentence and wonder if that can be explained. Also on that page, there's a reference to nitrate levels in the water supply for the Lower Waitaki scheme, sitting at approximately 50% of MAV, which is an area of concern. But if the levels are only half of the maximum, why are we concerned? And finally, on page 34, there's a reference to the land instability in Moeraki causing problems within the wastewater reticulation network. How substantial are those problems, and have they involved any realignment of the network itself?
Through the chair, I'll approach the second and third questions first. You may have to draw my attention back to which number 1 is. With respect to the maximum acceptable value, sorry, in there I do say in parentheses maximum acceptable limit, should be maximum acceptable value. It's of concern because there is currently a review of nitrate levels within water supplies, and there is some discussion within the water community that there may be steps taken to reduce the current MAV. We're not sure to what number that would be, but if it was reduced to say 50% of what the current limit is, we would no longer be able to provide water for drinking to the Lower Waitaki consumers. So steps are being taken from a long-term perspective, but it may become a more immediate issue in the short term if there is a change. Nitrate levels do slowly rise. They kind of come in peaks and then drop back away. So we're actively monitoring it, but we may not have a lot of notice for when we have to take steps to provide an alternative water supply to that community. With respect to the landslips within the Moeraki area, they are of concern. There's quite a lot of pipe now that we have sitting over top of land rather than buried. There was a particular issue last month where pipe work within a property failed, and we ended up with an overland spill. It didn't enter a waterway, but we ended up with wastewater running through someone's property. The pipes are pulled apart. They're twisted, they're bent, they're all sorts of things because of landslip issues, and we just have to try to address them and reorient the network when it occurs. It's not a particularly cheap network to try to operate because of that. Your first question?
The third one was that one on second paragraph, page 33. I just don't understand the last sentence. There remains one further outstanding issue with OHAL remaining to allow the water supply to have its permanent boil water notice lifted. Does that mean that there's one outstanding issue that needs to be resolved to allow, or what? Okay.
Councillor Sheik.
Thank you, Mr. Chair. Josh, I've got a couple of questions actually. Referring page 34, trade waste compliance. It notes that there's particular concern of one industrial customer that has recorded repeated exceedances. How does this actually work? Do we report a customer to Tomato ROI for exceeding parameters? Or is it basically the effect that the exceedance of these customers have on our overall testing and reporting requirements to Tomato ROI? I've got a couple of questions, but I think we'll take them one by one.
So Tomato ROI are only concerned about water compliance. They're not concerned about wastewater compliance. Trade waste affects our resource consent obligations, which would be to the regional council, ORC or ECAN in our case. Trade waste itself is not of concern for them, providing our scheme is permitted to accept trade waste. Trade waste limits being exceeded is a regulatory concern for us as the receiver and the person who issues the licenses for discharge.
Thank you for that. So the next question obviously would be, well, what are we doing about it? As in, how are we going to make this particular trade waster responsible for what it's doing?
Yep, I've had several meetings with them over the past 12 months. We have put them in touch with a number of different process engineers that can help them refine some of their pre-treatment processes. We have active contact with them in terms of reporting back to them their exceedances. Because it is a significant customer, it requires a significant investment of both time and money into resolving the issue. So I suppose at this point, it's a very active communication. It's been a slow process rather than, I suppose, a swift one that ceases or discharge, because frankly, I don't think that they'd be able to continue to operate if we were to take those kinds of steps.
All right. The traffic light tables are great. Now, I received an email from Tomato ROI, and I'm sure you've got it as well, about the new parameters that come in effect on the 1st of July. So are these tables going to change because of the latest parameters that come into effect, or we're pretty much going to stick with what we've got here, what you presented here today?
I would need to double check one or two parameters. For the most part, though, they change some of the monitoring requirements as opposed to some of the infrastructure requirements that we actually need, or some of the treatment requirements. So I'd say that there'll be largely no changes. I don't think that there's any of these exceedances at the moment that are due to testing issues. But they wouldn't be resolved in any case. So no, I don't think there'll be any large shift.
Final one then, if I may, Mr. Chair, is great to have this explained to us in this format, as in stoplight. I just wonder, great believer in celebrating wins as well. Would it be a lot of work if we just had a column next to it that says, this is where we started off. We've got a year to comply before things are out of order, so we can actually see some progress with one blink of the eye?
Yep, can do. So since taking on this position, I suppose I looked at the previous annual report from when I took it over and said, right, that was the current lay of the land when I took it over, and this is where I want to get to. So I'm looking at a 12-month change. But if you'd like to see something a bit more regular as we report these, happy to do that.
I for one would appreciate it.
Yeah, and look, I was heartened to see in the last committee some of the progress type reporting that we were seeing, so we can see changes and see what sort of actions we'd agreed on whilst we're only receiving this information. It's something that I'd like to discuss further, just to see whether we can see, because I think celebrating wins is just as important as looking at what is there coming up, but also knowing what we've achieved and where we're moving forward. If there's no more further questions, I'm looking for someone to move that the Assets and Infrastructure Committee receives and notes the information. Councillor Slack, seconded Councillor McCone. All those in favour?
Right.
And against? That's carried. Okay, well, look.
Chair, I'll move the recommendation on page for recommendation under public excluded 6 that we go into public excluded.
Thank you,
for
councillor.
following parts of proceedings of this meeting.
Thank you, councillor Hopkins, and looking for a seconder. Mayor Tappendale, thank you. And with that, we are moving into public excluded. So for those who are joining us online, thank you very much, and hope you have a good rest of your day. And we'll move into public excluded. Those, well, they're joining us. They're still online.